everybody. We are team number 2, integrated by Jose Ricardo and Jose Miguel Quiserio, and we want to talk about the exhibition of professional services contract. For the first part, we're going to talk about the main obligations and rights of professional practices in Mexico. And we are going to analyze three documents: the political constitution of the United States of Mexico, the Federal Civil Code, and the regulatory law of Article 5 in Mexico City. In the first one, in the political constitution of the United States of Mexico, we have some rights related to the constitutional guarantees that which every individual in the United States enjoys the guarantees granted by the Constitution, which cannot be restricted or suspended except in the cases and conditions established by the Constitution itself. The prohibition of slavery, prohibition of discrimination, freedom to choose a profession, industry, trade, or work. It means that no person can be prevented from engaging in the profession, industry, trade, or work of their choice. Limitations of this freedom can only be imposed by judicial discrimination to protect the rights of third parties or by governmental resolution in accordance with the law to safeguard the rights of the society. The right to the product of labor, the freedom to choose a profession with conditions established by law, right to just compensations and consent in personal work, prohibition of contracts and diminished personal freedom. And there's some other obligation like the mandatory public services and compensation, the prohibition of proscription or renunciation agreements for a profession, limitations of in employment contracts, and the civil liability for breach of employment contract. For the next document, we're gonna analyze the Federal Civil Code, and we have some specific rights that clearly we can see in the document. The right to agree on compensation, the right to observe union provisions, and the right to free regulation. This means that in absence of an agreement, fees can be regulated considering factors such as local customs, the importance of the work, the significance of the matter, the financial capabilities of the recipient, and the professional reputation of the provider. If there's a fee schedule, it will be served as a standard for setting fees. There's other rights are the right to include expenses in the services rendered, and the right to to charge fees regardless of business success. So in the part of the obligations, we have the obligation to regulate fees in the absence of an agreement, the obligation not to charge for services without the corresponding title, the obligation to notify in case of inability to continue. This means that professionals have the obligation to promptly notify if they cannot continue providing the services. If they fail to do so, they must compensate for the damage caused. Payment of obligation and the professional place of residence, joint obligation of persons entrust a business. It means that if several individuals entrust a business, all of them are jointly responsible for the professional fees and advance made. Obligation to notify in case inability to continue, especially for lawyers, and the limited liability for negligence, incompetence, or fraud. In the last document, the regulatory law of Article 5 in Mexico City, we can see more specific rights on obligations points. Or, for example, in the case of rights, we have the right to professional practice. It means that professionals have the right to engage in habitual acts or provide services inherent to their profession, whether on paid or unpaid basis in Mexico City. The right to judicial representation, the right to authorization for interns, It means that interns have the right to obtain authorization to practice for a maximum of 3 years, subject to evaluation and approval to the Secretariat of Public Education, the right to establish fees, the right to provide services through retainer, the right to professional association. And this means that professionals have the right to associate to practice their profession adhering to relevant laws. In the case of obligations, we can see the obligations to fulfill requirements for practice. It means that professionals have the obligation to meet the established requirements for practice in Mexico City, including being in a full enjoyment of civil rights, possessing a legally used and registered title, and obtaining an exercise license. Obligations to maintain professional secrecy. It means that professionals are obligated to strictly maintain the confidentiality of matters entrusted by their clients, except for mandatory reports established by their respective laws. Um, Obligation to fulfill contracts and provide services, obligations in emergency cases. This means that in cases of urgent and unavoidable situations, professionals are obligated to provide the required services at any time, at any place, within the limit of 25 kilometers from their residence. The obligation to participate in profits, the obligation to adhere to professional ethics. It means that professionals have their obligation to align their advertising or promotion with the concepts of professional ethics established by the respective professional association. An obligation to communicate disqualification resolutions. Now it's time of my teammate Ricardo.
Hello, everyone. My name is Ricardo Ortiz, and I'm going to tell you about the clauses of a professional service agreement, or PCA for short. But before we get to that point, let's start by knowing what's a professional service accord or agreement. A PCA, or a professional service agreement, is a legal form between two parties in which one agrees to provide a specific service in exchange for financial compensation from the other. It lists the services that the consultant will perform, the compensation that the business will provide, and the time frame for the contract. Because many PCAs also detail procedures, terms, requirements for the service. They can be several pages long. Next, I'll give you some examples of the clauses that you will find in a PCA. For example, the signer and the assignee are the parts that are the part of the agreement. The period of time that both parts agreed on, the assignee responsibilities that are the deliverables that the consultant will provide, the workplace where the consultant will work or when it's work, and finally the compensation that the consultant will know the other part for lending the services. Okay, for this case in specific, I'm gonna show you a comparison between two PCAs. The first one is between Sinaloa's Electoral Institute and a woman called Rosalibet, and the other is between the with Veracruz state government and a man called Ismael Garcia Mendes. Okay, first of all, the clause of agreement length. As I said, setting a length for the agreement is imperative for both parts because there are specific things that must be completed in a limited time, or just having someone to do the job until you find the right person to do it. Uh, it can be months, it can be years, or it can be in indefinite time. The contract object and agreed professional services. When setting an agreement, both parts must state the general nature of the agreement and state the specific services that the part is going to do for the other. Of course, lending the services must come with compensation. Nobody works for free. Both parties must reach an agreement to be in equal terms between responsibilities and insurance. As of it, the agreement and its contents are only changed by can only be changed by both parties involved, and the consultant is the only one that can do the job without the help of others. Having some relationship with the previous point, both parts agreed that any content or anything that is made during the agreement known only between both parties. There is not there cannot be another person that can know about the contents of the agreement or what the parts are doing during the agreement. Interruption. During the agreement, internal or external causes can bring some difficulty for both parties and guide them to rethink the agreement itself. At some point, one of the parts will give in midway and leave its part. Obviously, this will have some implications and measures to deal with. Obviously, in case of an extraordinary way, this can be avoided, but it has to be an extraordinary case. Terminations. When a contract is signed between the parties, there are some rules that are set to follow while working under the agreement. If one of these is broken, the other part is on its right to terminate the relation and punish the other part for breaking the rules according, obviously, to what was the rule that it broke. Conflict resolution. Both parts at some point will have some differences of the thinking of the way that is the are doing the job, but they sign a contract where they are both both in mutual accordance to solve problems on mutual agreement, following the laws and regulations that or of the place that the contract was signed. Obviously, the previous point enters in this new point. When signing an agreement, you need to know uh, which laws are entering in this agreement, and you have to know it well because you have to be careful about not breaking any rule, any law, uh, and so they can finish the accord without any problem at all. And that's it.